Where we left off last time was we had finished looking at the investment in U.S. property rules, which was Section 956. And we're still, let's say, using the statutory framework as a way of discussing some of these areas. So we'll finish that statutory framework and then look at a few special areas. Now we're getting into, let's say, the question of what is a CFC. We've been spending a lot of time talking about CFCs, controlled foreign corporations, but we have not actually defined what they are. Now we're going to define them in 957, and there's attribution rules in 958, which help us in the definitional process. Okay, so what makes a foreign corporation a CFC? First is that more than 50% by vote or value is owned by U.S. shareholders. Owned or considered as owned. And the considered as is coming from the attribution rules. So what are we talking about there? Let's just draw a picture or two. Let's say we have 3 shareholders of one corporation, and maybe this one also owns another company which has an interest, and let's say that it's what should we say? 5% here, and maybe 100% here, 5% here, and maybe 40% here, and let's see, that gets us up, and then 50 over here. Now, let's say that the only U.S. persons are this one and this one. We want to know whether X here is a controlled foreign corporation. Is it owned more than 50% by vote or value by U.S. persons? Now remember, we said U.S. persons they are 10% or greater shareholders. So I guess the first question, in a sense, is this one here. Is that person or that company, is that company a U.S. shareholder? It is, and why?
The attribution rules?
Yeah, the attribution rules, because what a corporation owns will be considered as owned by that person. And remember, generally speaking, the CFC rules are meant to, let's say, punish people for how they conduct business. So there are attribution rules to try to bring into account a very wide range of situations. Again, the contrast we mentioned, I think last week or the week before, was that by contrast, the deemed paid foreign tax credit rules are granting a benefit. There are no attribution rules. So here we have attribution rules. The Congress wanted to cast a wide net. Okay, so now we have two U.S. shareholders. Let's say that this one is W and this one is Y. Do W and Y own more than 50% by voter value? Well, in this simple example, of course, they don't. So we do not have a CFC. But is this, for example, enough of an investigation? Do we perhaps have to look at the actual terms of the shares that are issued by X? Remember, corporate law allows different series or classes of shares. Some might be voting. Some might have preferences of one sort or another. And as a result, if there are more than one class of share, this might not be enough information. Now, this is a very mechanical test. And I think you will have hopefully read the Framatome case. Anybody remember a little bit of detail about that? Because maybe this is a good time to discuss that. Because we're talking about the mechanical process. In the Framatome case, who was the U.S. person? Okay, Burndy, U.S. And what percentage did they own of the Japanese subsidiary, or the Japanese company? 50%. Right. At the time of the case, they owned 50%. And who were the other shareholders? What was there? A Sumitomo and... Pardon? Furukawa. Okay, so Furukawa. Okay, so we have two Japanese parties here. Now, this case is kind of funny because usually, of course, you think that a U.S. shareholder doesn't want to have a CFC. They try to avoid CFC status. But that's not this case. In this case, the taxpayer wants CFC status. He says, you know, I should be the one who, you know, has to recognize subpart F income if it occurs. Anybody remember why they wanted CFC status? What was the background to that? Yeah, this is kind of interesting because this was a very, very domestic Japanese business. There was no subpart F concern. There was a you know, number one, the business was inside Japan, so it didn't come into the various tax haven types of income, foreign personal holding company income, foreign-based company sales income, and so on. It was a domestic business in Japan, so these were not an issue. And as a result, there would be no subpart F inclusion. They just weren't worried about that. But they did get a much better answer under the foreign tax credit rules if this were a CFC. Remember, Japan is a high-tax country. Back then, at that time, there was roughly, on distributed earnings, around a 57% Japanese tax, give or take a bit. And, you know, that was much higher than the U.S. tax at that time, which was, 34, 35%. So if they could get a better answer from a foreign tax credit situation or perspective, they'd be much better off. So they were claiming that, yes, this company is, in fact, a CFC. Were they successful? And if not, why not? Yes?
They didn't have over 50% ownership. They had 50% ownership.
They had exactly 50. Okay, now that sounds like a pretty black and white thing, that they had exactly 50, and of course the law says over 50. How were they trying to make a claim that this was a CFC?
They were trying to say that they had power to influence the other two for voting rights, and they had veto power and stuff like that.
Yeah, so they were, and I think they also said something to the effect that, well, gee, because we have 50%, there should be a valuation premium because we have such a big block of stock in comparison with the other two that only had 25%. Clearly, much more minority positions. And the court basically laughed at them and, said, you're wrong. This is a black and white test. You cannot claim that you really own more. You can't use a substance argument because that's really the sword of the tax authority. So they said, this is a black and white rule. It's black and white. You own 50%, not a bit more. You're out of luck. I believe, for example, let's say that they got Sumitomo and Furukawa to agree to hold the shares in the form of a partnership. Let's say that they got the two to agree to own the shares through a U.S. partnership. Is there in substance any difference from this situation if we merely put in between a U.S. partnership so that all three owners legally own an interest in a partnership, and that partnership owns 100% of the Japanese company? Is there in substance any difference? Yeah, well, no, yeah, you're right. There's really no difference. There's some legal differences, of course, but economically and control-wise, there's absolutely no difference. Is this now a CFC? Yeah. So if they had, if I remember the facts of the case, they started treating this as a CFC in 1987. They had 4 or 5 years to do something that would make it solid. And they didn't. Now, back in those days, trying to convince the Japanese, because these were the years that I was living in Japan, so I know that this would not have been an easy sell. But they had a number of years where they could have put something like this in place, and they could have been assured of their answer, or relatively assured. Of course, the U.S. authorities perhaps could have tried to use a substance over form argument and ignore the existence of the partnership. But I think that might have been a hard sell for the court to agree with the IRS on something like that, because once you put a real live partnership in between that is respected by the state of organization of the partnership and is respected by the parties, that's a pretty solid form, even though, again, it doesn't change anything in terms of substance. So very often with these kinds of black and white rules, thinking outside the box a little bit can get you to where you want to be. And again, looking back at this, they had, 5 years from 87 through 92 to put something in place to give them a little bit more security. And they didn't do it. Now, when we get into the regulation, we, of course, see that voting control is based on facts and circumstances. So even though percentage-wise, maybe a shareholder only owns let's say a small percentage, and the small percentage is at least 10%, because if a person doesn't own 10%, then of course there will be no status as a U.S. shareholder. But even though a person may economically own only 10%, they can have voting control, and that could happen through different classes of shares or through mechanisms that are built into the corporate documents. If you have voting procedures that are in the corporate documents that provide for one 50% owner, for example, to have the controlling vote anytime there's a deadlock, well, that's control. And again, remember, these regulations are written to be broad because most taxpayers don't want to be a CFC, don't want to have their foreign company be a CFC. Let's look at the wind course fact pattern situations, and or at least several of them. The first one we've already effectively talked about, where there's attribution through another company. The second one, okay, the LLC's organizational documents provide that Win China LLC as unit holder will have a deciding vote in the event of any disagreement between the unit holders. Okay, so that's a typical kind of thing which you can find, and this would cause CFC status. Take a moment and read the next one, the Waman Win CJV. Now, this particular situation does not have a clear black and white answer. But what I think would be useful is to talk about this from the standpoint of how do we analyze a situation like this. And for what it's worth, one of the clients I worked on when I was in China had a situation very close to this. So this is, again, not uncommon. Now, any thoughts as to how you analyze this thing? Maybe a good point to always think about is when you have a situation where the facts are pretty muddled like this, the starting point is really what do we have legally, what is legally created, in other words, to describe that. And then to go to the next question, which is, well, is the form that has been legally created, is that form likely to be respected by the authorities? Are we respecting the form we create? In other words, really getting to a substance versus form question. Only once we've decided what we really have, can we then go to the statutory definition and the regulation, that interprets the CFC definition and attempt to come to an answer? So really a first step is, what have we legally created? What is the situation here? Let's attempt to diagram it a little bit. That may help our discussion, I would think. Okay, we have a Chinese cooperative joint venture, and one shareholder is, what was it? It was the Hong Kong holding company of Win. Win is at the top, and they have 49%. And the 51% owner is an individual who is an employee of Win. And we also said that, I don't remember whether we indicated it specifically, but let's say the Hong Kong company presumably made a loan of the money that is that the employee used to invest in the company. We also said that the organizational documents down here, that what they do is they do not necessarily give the Hong Kong owner any specific rights that it can exercise. Rather, it says that certain decisions must be unanimous. So, for example, if the CJV is going to get into a major contract, both parties have to agree. If one party is going to sell its interest, there would be, that presumably would be effective also to prevent free transferability. So through this mechanism of, in a sense, being able to not agree to something, Win has some measure of control. But on the other hand, what about the individual? Could the individual exercise the same veto powers over something that Win wants to do? Well, yes, he could. Is he likely to do it? Well, maybe not. His salary is being paid by Win. So, how do you look at this thing? There's no restrictions on him, in a sense. He has full ownership rights. It's just that he's probably not going to try to exercise them. So you can have situations like this that are really not black and white. Now, I sort of alluded when I first said, how do we analyze these things? I alluded to the fact it's not just how the tax authorities treat this. How would they, the tax authorities view it? But how do the parties act, both within internally and to third parties? Well, what third parties might we be concerned about? Well, Win up there prepares consolidated financial statements. There are accounting rules that deal with something called variable interest entities. And in a situation where maybe, let's say, less than 50% or 50% or less is owned, but where economically they believe that 100% of the earnings are really, really belong to Win, then the consolidated financial statements would include the operations of this CJV. Now, if Win, to its shareholders, to its creditors, to everybody else, is saying, hey, we really own this whole thing, and we're including in our consolidated financial statements 100% of the activities of this company, that says something about at least what they believe and how they are respecting or not respecting the form that they have created. Now, this is a very small discussion of a very large area, which we'll talk about a lot more in the spring course, but I hope it gives a little bit of a flavor of this substance versus form issue as to how you sort of have to look at them. Did you have something to say?
Maybe. Well, I know I have something to say. I'm just curious. Are we just assuming that the Win is a Win CJV is a foreign corporation?
Very good question. If you go through the questions, that are in the for anybody who has this case for part of the group project, you'll see assume this, assume that. You're absolutely right. So there needs to be answers assuming one way, assuming another way. Yeah.
I had a question about
Yes.
that generally. When you're talking about, when you're doing that kind of analysis for like, is it a foreign corporation? You're not, do you need to worry about the check the box rules at that point? Or no?
Well, yeah, let's put it this way. We have two possibilities, and this is a black and white thing because we have check the box rules. Is the CJV going to be treated as well, number one, is the CJV an eligible entity or is it a per se corporation? Okay, in this case, it's an eligible entity. In other words, if you look down the listing in the 7701-2 rules, you would not see this listed. So a CJV in China is an eligible entity. So the question then becomes is, of course, what election was made? Did they use a default rule? Did they make an active election? And if it's a default rule, then, well, is the CJV under Chinese law could be either limited liability or unlimited liability. So you'd need to know by looking at the corporate documents and the underlying law what the status is. Now, I'm assuming for purposes of this discussion, since we're talking about CFCs, I'm assuming that the CJV is in fact it's treated as a foreign corporation under the check the box rule. So yes, I'm assuming that for this discussion. If we did not have it treated as a separate, a taxpayer, as a foreign corporation under the check the box rules, if we treated it as a partnership, two owners, therefore partnership, not disregarded entity, then we would not have a CFC issue because the Hong Kong company we know is a CFC because it's 100% owned, and assuming it is a foreign corporation under the check the box rules. So we don't have a subpart F issue with regard to the Chinese joint venture if it's a partnership, because CFC rules are only for foreign corporations. They are not for partnerships. Although you do have the question, which is, are the operations of a partnership attributed to the partner that's a CFC? So that if, so that will you have in the hands of the Hong Kong company subpart F income from the income earned from the partnership? So you could have that. But you don't have the question of, is this partnership a CFC? That you'll never have. Is that help a little bit? Okay, so getting back to the original point, there's no right or wrong answer on absolutely whether this in substance is a 49-51% joint venture, or whether it should be treated under U.S. tax concepts as being 100% owned by the Hong Kong company and just zero owned by the individual, because he's in such a dependent relationship that he should be thought of, in a sense, as an agent of the Hong Kong company. So I'm not trying to suggest that one answer is right or one answer is wrong. There's those two possibilities. And it might be very, very difficult to come up with a real hard answer. Now, if the form is respected and it is 49-51%, then we obviously don't meet the over 50% test, and we do not have a CFC. On the other hand, if we say that the individual, the employee, is really just acting as if he's an agent of the Hong Kong company, then yes, we do have a CFC, because very clearly then we have full control over the company. So you can run into things like this. They do exist. And like I say, this issue of how you approach and try to analyze a substance versus form situation is particularly important in many, many areas. Obviously not just this one.
Is it possible that the substance will prevail under the form?
Is what possible?
Is it possible if the substance will prevail under the form? So if it says 49% and 51%, it's definitely minority, I mean, in terms of
Well, if it's the order of analysis is you make a decision on what the real substantive fact is. Now, the substantive fact might be that you say, gee, the form is right, and Hong Kong owns only 49%. Or you might say, well, the real substantive situation is that this individual is really acting as an agent, and therefore the Hong Kong company owns 100%. In other words, you first have to make that analysis and decide one or the other. And then once you've decided which it is, then you apply the black and white test, so to speak, of 957 to define the entity as a CFC or not.